Good afternoon. Good afternoon. Are you going to court for the first time? Are you unsure what to expect? Do you think it will be as high stakes and dramatic as the movies and the TV shows where anything wild and crazy can happen? Or are you just nervous because you've never been to court before and you don't know what to expect and you're just a little bit intimidated by it all, by all the attorneys and the judges and all the people in the suits, maybe even jailers, who knows? But you just kind of have this uncertain feeling, this fear of the unknown kind of feeling going on. If you do, that's okay. It's very common. So listen up today because we are going to go over a few tips that will help you prepare and get the best out of your court experience. And just to let you know who's helping you today, I am attorney Tina Patterson. I am an attorney here in Michigan, and I am the principal attorney of Patterson Justice Council, headquartered in Detroit. And I've been a practicing attorney for 10 years in and out of courtrooms from municipal levels through appellate courts. So all up and down the system, and I've helped clients get results. But one thing I really enjoy doing the most is just preparing the clients for what to expect. Because I think that preparation is so key because it will then control and influence expectations. Okay. So when you're not sure and you kind of have this fear and worry going on, that kind of energy can then translate into what you expect, into the outcome of what can possibly happen. But if you prepare well ahead of time and you kind of get those nerves under control, then you can go into court feeling a lot more confident about your outcome. So today I'm going to talk about 4 tips that you can use to prepare for your court hearing or your court case, your court date, whatever it may be. Okay. And this is pretty general. We can go to court for a variety of reasons. Okay. But generally speaking, these are always some tips that you want to try to use just to ease the tension that can come up with a court situation. All right. So, number one, which is very, very important, schedule a meeting with your attorney. If you don't have an attorney and you're self represented, do these things for yourself. All right. So, without the attorney, still do these things. A good pre-court preparation meeting with an attorney, or like you said, if you don't have one, is going to go over your case, right? You're going to review the facts of your case. You're going to review the details. You're going to review, if you put forth a document, you're going to review what it is that you're asking for in court. If the other side did, you're going to view what they're asking for and then your counter, right? So you're going to review both sides of the court filing, because usually a court action will come with a filing, right? Somebody is asking the court for something. You're going to review that and you're really going to hone in on it because a lot of times you're scheduled for that particular issue. All right. So you don't want to veer off track. You want to keep it very focused, very tailored to what the court hearing is going to be about. So you want to go over those case facts, those details, review it so that you know it. I mean, there's nothing better than going into court and you know your case. All right. A lot of times, especially when I see it, parties, people that don't have attorneys, they'll look to the other attorneys that are opposing them, or they'll look to the judge for guidance. They are not advocating for you, right? You're advocating for yourself. And if you have an attorney, they're the person that's representing you. They're the person that's advocating you. If not, it's you. But ultimately, your attorney, you guys have to know the case. You have to know what you're asking for. You have to know. The judge is not expecting you to know, or is not expecting to speak for you. The other attorney is certainly not speaking for you. Okay. You have to be able to speak for yourself, know what it is that you want, and argue that or express that confidently. So that's where preparation is key when it comes to the facts of the case, the details of the case. Another thing that you want to speak with your attorney about, or if you don't know, review for yourself, are the court rules and processes. So, what judge are you going in front of? Do they have particular rules that they're very adamant about? Um, is there something you need to do beforehand, like call the court clerk and let them know if you're going to be running late, or check in on time? Like, know those details because that'll just make you look more confident, and it will give you a feeling. Anytime you have a feeling of more competence, it's going to bring more confidence because, oh, you do what you're doing and you were doing it right. Imagine like when you learn how to ride a bike for the first time, you had to fall in so many times and you feel like you can't do it. But as soon as you take off without those training wheels, you know how to ride a bike now and you feel so good, right? The same thing when it goes to just knowing the ins and out of a courtroom. You know what to do, right? So you're not nervous. That feeling of nerve just kind of dissipates, right? When you don't know something, then that's when those bubbly feelings come up because it's just unknown, it's out there. But that's again why preparation is so key, because you can squelch a lot of those nerves just by knowing beforehand. Okay. And when it comes to court processes, how the hearing is going to work, the mechanics of it, very important to review that. And a good attorney is going to let you know, and you'll have a sense of certainty about it walking out of your preparation meeting and going into court that next day or whenever it is. And one other thing when it comes to this meeting, explaining proper court decorum. How are you supposed to act in court? How are you supposed to look, right? How are you supposed to behave? Knowing if you have to go physically in court again, because a lot of stuff is still virtual, knowing where to sit is even something, right? Plaintiff sits on this side near the jury box. If you're on the other side, you sit over here. Like knowing these small things will just build so much more confidence in you and in the outcome, because you're not worried about how you're going to look. So much of it is presentation. And, while that's not a big thing, missing it can cause this like huge reaction. Like, oh, I should have. Just relax. Okay. Know as much as you can beforehand. A good review meeting with your attorney. If you don't have one, a good review meeting for yourself, maybe talking to others who might have been there or looking online, reviewing judges' court rules. That will help you a lot. Okay. So that was number one, scheduling that pre-court preparation meeting. Number two, don't be nervous. Okay. Again, in this, having that good preparation meeting is going to go a long way into just stretching those nerves out. All right. Don't be nervous. And everything I'm saying here are things that I've done, things that I've counseled clients on, and they have worked. All right. And I'll kind of explain that toward the end a little bit. But don't be nervous. Be calm, be cool, be very relaxed, very certain. Uh, you want to present as if you're certain. Even if you feel like this ball of nerves, just be okay. Be okay. Don't be nervous. You don't need to tell anybody you're nervous. You don't need to tell anybody it's your first time in court. You don't need to say anything. Okay. We'll get into what to say if asked, but you don't need to bring those kind of nervous feelings up to the surface. No, just kind of let them dissipate again. And a good preparation meeting is going to really calm a lot of it, because that's where a lot of your questions are going to get answered. And now that you have answers, you're not going to be feeling like you don't know what to do. All right. So don't be nervous. Third, I'm going to say is to answer questions directly, but don't answer more than what is asked of you. So once again, a good preparation meeting is going to go over this. A lot of times, even with an attorney, clients, right, or the people involved who are not the attorneys may speak from time to time. They might have a question from their own attorneys, right, to confirm something. They might get cross-examined by the opposing counsel, and not like a full-length one, but they just might be asked questions, right, by the other attorney. They might be asked questions by the judge. And almost all judges are going to ask you your name, at least for the record, right? Just to know that you were there at the hearing. Answer the questions very directly. That means if they say, "What is your name?" Tell them your name. Don't tell them what you do, where you live, where you work, all that stuff. That's not what's being asked of you. Okay. And so there are a couple of reasons why you don't want to do that. Number one, um, because you don't want to offer more information than is necessary for you. Everything is going to be recorded on the record. So that means that everything can be used in any way. It can be used for you, it can be used against you. So only ask what the direct question is asking you. Limit it in that context. Number two, also, is that it's not necessary. I have been in many courtrooms where someone is asked a question and they just ramble on and they're cut off, because we don't need all of that extra. Okay. They're either cut off by their own attorney, all right, they're cut off by the other counsels asking the judge, that's it. Or the judge is asking them a question directly or giving them another opportunity to respond, and they're still talking too much and they just limit it. So you don't need all of that extra. All right. Be very concise, be very clear, and keep it at that. No need to offer more. Okay, so that's number three, asking questions directly. Number four, I was gonna say is three, but since we're talking about, how you answer, number four, I'm gonna say is be honest. Okay, if somebody's asking you a question and you have an answer to it, just be honest. Your attorney will kind of, counsel you into how to answer it, always honestly, but obviously, there are some things that may be asked of you that may not look good on you, but we can always use even truthful, bad information in your favor. Okay. And even just being honest in and of itself is credibility for you. Okay. 'Cause you can say, yes, X, Y, and Z, I can take responsibility for that, but X, Y, and Z. All right. Um, just for instance, like if I was in court and I was being asked a question and something came up that I was supposed to do, I didn't do, I can say, yes, Your Honor, this is true. I should have, or I didn't, reach out to counsel directly. I didn't reach out and give them a phone call, and I take responsibility for that. However, this was discussed in previous XYZ. You're right? Something very simple like that. And it's not lying. It's very honest. It's very open. It's very transparent, and it builds credibility for you. And that goes a very long way because the court process can be very adversarial. That means obviously you're butting heads. There's a lot of conflict that can be involved. Not always, but a lot of times, right? So that part of the TV dramas is true. Okay. But the more that you are very rooted in your answers, the more honest that you are and you can stand on that, the better and the taller you are going to stand. All right. Even if something looks bad on you, that part will shine through. All right. And so you're going to be credible. And another thing when it comes to being honest, if you have the answer, say it. If you don't have an answer, you do not need to make something up for an answer. So this is very key. If you don't know, it's okay to say you don't know. Honestly. Do you know where X, Y, and Z was on the night of X, Y, and Z? Your Honor, I don't know. And leave it at that. If you don't know, you don't know. Now, don't lie. If you have information, to the extent that you can answer it, do that, right, in an honest manner. And I'm not telling you to go on the record and what's called self-incriminate yourself, right? You heard the term of pleading the fifth, right? Nobody's asked you to go tell on yourself in front of court. What I'm saying is, if you're asked a question, a very simple question, you can say like, you can be asked, well, how long did you work at the company? It was so long ago, I don't remember, right? Or, I don't have a direct answer, but maybe I would say about 10 years, but I'm not sure, right? Those kind of things, that's okay to say, okay? And again, your attorney will counsel you through these kinds of scenarios, will counsel you on how to answer these kinds of questions. And it is really very simple, right? Because at the end of the day, it's like you have the yes or no questions, and then you have questions that have direct answers. And if you don't have those direct answers, I'm not sure, but I can get back to you. For example, a lot of attorneys sometimes will be asked about a particular case they may have cited, right? Which means there was a case that had been ruled on, and they used it either to, excuse me, to support their own case or to attack the other party's case. And the judge might ask, well, where is this case cited at? It means like, how can you pull it up? Where is it? And an attorney can say, you know what, judge, I don't have it. Or, you know what, judge, I'm not sure. I thought I had it. I can get back with you on it, right? But there's still an answer. Even if it's an answer that it's not very specific in the moment, there is still an answer. There is still a solution there. Okay, so that kind of stuff we can do. But again, when it comes to, especially with criminal defense, and this is why so many people don't put the accused on the stand, because it's not their job to tell on themselves. It's the prosecutor's job to prove beyond a reasonable doubt whether they did it. Okay, so those are two different objectives. All right. So again, when it comes to being honest, answer the question directly. You don't need to go telling on yourself, right? But you don't need to make up an answer, and it's okay for you to say, I don't know. And again, this is all generally speaking. If you have a very, very particular issue, definitely contact your attorney or another professional who can counsel you furthermore. All right. But all this is just for general educational purposes to get you an idea of what to expect and how to present yourself in the best light possible. All right. And one more thing I'm going to say with all of that, I think, is to just be positive. Okay. Be positive. You don't need to be worried or nervous. Don't bring in upsetting emotions. Don't bring in any disappointment or frustration. Your attitude is really everything. And I'm going to use a couple of examples now just to demonstrate this. So, one is for my own daughter. She plays the violin, and she doesn't like to practice a lot, and I'm sorry. I know she doesn't like me telling this, but I told her the same thing, so it's nothing that, is unknown to her. And a lot of people just they don't like to practice the things that it is that they have to practice, okay? And so when I ask her to practice, she like, you know, pull her shoulders down and it'll be really rigid, and she'll miss notes. And I'm like, "I can't even hear the sound. I don't even know what kind of song you're playing right now because it's just so, choppy." And I know that's not how you play. I know you know these notes. I know you can play them well. So it's not a head thing, it's an attitude thing. So I was like, "You know what? Imagine that you're going to play this instrument, you're playing this song, and it sounds so beautiful and it sounds so lovely, and your notes are hitting, and everything is just sounding exactly how you want it to sound." And as soon as she just takes a deep breath, lifts her shoulders back up, and plays with that kind of energy, with that kind of attitude, all of the notes sound correct. Like, literally, there's no choppiness, they're flowing, the bow is not hitting a different string so that there's not 2 and 3 different notes playing at the same time, everything is in sync. The same applies to your attitude for anything else in life, including how you present yourself in court, how you answer questions, right? So the second example is just with the court hearing that I had this week with some clients who I was presenting to or preparing, quite a few days ahead. Then we also had a very, very good pre-court hearing meeting the day before the hearing, and it was excellent. We talked about all of these same things. So again, I alluded to it earlier. Everything that I'm telling you now, I've told clients before just within the last week, and this is not the first time. All right, so I don't give out this kind of information without using it and testing it and seeing if it works. So to that point, my clients, we've talked about all of these things. We talked about attitude more than anything else. Obviously, we got into the facts of the case, how the court process is going to run, what to expect with the itinerary and all that. But I said, above all else, just be positive. Don't be nervous. Don't be intimidated. If you don't know something, that's okay. Just answer honestly. And when I tell you they showed up sharp, they showed up so sharp for that court meeting. I was so proud, and it just feels so good to like prepare somebody and they show up and they step up in it and they look their best and they're showing up and demonstrating at their best because it's possible for them to do it, right? It's just a matter of very, very good preparation. And they were excellent. And we had a very, very good hearing. And they were just overjoyed afterwards. Case is not over yet, but like that was such a great, tremendous first step. That we all just felt so good about it. Okay, so that's why I say attitude is everything. And I told them this, and I'll tell you this, and I'll tell anybody this. We always hear like the Monday blues, and oh my gosh, I hate Mondays, all this stuff. I don't subscribe to that. Yeah, I got it in the past, but no, no more. Monday is my day for a fresh new week. And how do I want to start my week? On a good high note. And I do that every Monday. Every Monday. For like the last 2 years, I've been doing that consistently. And so I told my clients, let's start this Monday off the best way possible, right? Let's have a great Monday morning, bright and early in that courtroom. Let's start it there, okay? So positive thinking will produce positive energy. It will produce positive words and behavior, and this will help to influence a positive outcome for your court case. Stay in this zone, all right? Don't filter back into the negativity and all that stuff. It can be harder when you don't have an attorney because your attorney should be your advocate in this as well, right? Not just in your specific legal issue. The law is one thing, but the law is not the only thing in a court case. I'm telling you that right now. I've said to clients many times before, the law is the easy part. The hard part is the people. The hard part is the attitudes, the emotions, right? The conflicts, all the other stuff that goes along with it. But the actual written rule of law, that's easy. There's always a solution to that. Okay. So these things are what you really want to focus in on. These things go a long way towards being prepared for a great court hearing and a great court case and a great outcome. So you want to keep these in mind. I do have a few other tips I want to share, but I might do have to do a part 2 on that just to keep it to time. But I hope you found this helpful. If you have, please do like, share, subscribe, and let somebody know that, hey, this was really helpful. I think you can use it. Okay. Until next time, I will see you Thursday, May 9th. I might have a few surprises there. We'll see what to do. Okay. But this is Attorney Patterson of Patterson Justice Council. I'll see you then. Bye. Take care.